our relationship relates back to the year 1991, when students like us learned from him the service matter, and those who have not knowing Mrs. Nishtha Jaswal, who is the Vice Chancellor of Himachal National Law University, they all taught us the batch of 1991 to 1994. So we all students thump our chest to the fact that we have all studied from a professor who, I can say, because of his vast teaching experience of across pan-India, length and breadth, he has covered all. Without taking much time, I would request Sir, and while I ask Sir to take over the session, I'm just reminded Guru Gobind Tau Khade Kake Lagu Pai, Bali Hari Guru Aapki, Guru Gobind Diyo Batai. Over to you, Sir.
Thank you very much, Vikas Chatrat. I'm proud of you for this web series which you are taking and imparting knowledge across the globe. Today, the topic which has been given to me is about major and minor penalties and procedure and the legal perspective. The topic is very wide in it, but I have been asked to cover in the shortest possible time. I will try to finish it within the stipulated time. Before I start the topic, I would like to make certain general statements which are very much relevant to the topic. One, when we talk about major and minor penalties under the service law is regulated by the constitutional provisions, the rules of the department, including punishment and appeal rules and the conduct rules of the concerned department, the case law, which lays down the case law which comes from the apex court and the high courts, and of course, the principles of natural justice. Two, the Constitution of India is a very rare document in which protection is given to certain category of persons, particularly commonly we call it the civil servants. Article 309, 310, and 311 are very much relevant in this regard. If you read Article 309, its operative part says, subject to the provisions of this Constitution, the appropriate legislature may regulate the recruitment and conditions of services. So two things can be regulated subject to other provisions of the Constitution: recruitment and condition of services. When we talk about condition of service, in it comes the imposition of the major and minor penalties and the procedure to be followed therein. I will, if time permits, elaborate this part of the Constitution subsequently, but for the time being, I just refer to Article 310, which is the operative part of Article 310 says, except as otherwise provided by this Constitution, every person who is the member of the defense services or the civil services of the Union or of All India services shall hold the office during the pleasure of the President, and in case of the state, during the pleasure of the Governor. What we commonly in the service law call that doctrine of pleasure is provided under this article. So when we talk about civil servants in general, Article 310 and 311, they come into play. Article 311 particularly talks about certain kinds of penalties which can be imposed on the service during the service on the employees. That Article 311 clause 1 says, no person who is a member of the civil services of the Union or All India services or of a civil services of the state and holds a civil post under the Union or the state shall be dismissed or removed by an authority which is subordinate to the appointing authority. So the rule number 1 is that two punishments, dismissal or removal, they can be imposed by a person who should not be subordinate to the appointing authority. We have under the relevant rules in every employment appointing authority which is prescribed. Article 311, Clause 2 is more important, which says that no such person shall be dismissed, removed, or reduced in rank except after inquiry in which he has been informed about the charges against him and given a reasonable opportunity of being heard in respect of those charges. Now, this article as such, or this clause 311, clause 2, does not lay down the detailed procedure how the reasonable opportunity of hearing is to be given, how the delinquent is to be informed about the charges against him. It talks about that holding of inquiry is mandatory requirement, otherwise it will be unconstitutional to dismiss a person or remove a person or reduce a person from the rank. And then there is a proviso which has a further proviso, and 3 exceptions are given in which no inquiry may be held. This is very important to lay down the background, and that is why I'm referring to. The first one is where the person is being dismissed or removed or reduced in rank on the ground of a conduct which has led to his criminal conviction, then inquiry can be dispensed with. The reason is the probability of proving the evidence in criminal trial is much more difficult as compared to the departmental inquiry. And if a criminal trial is there in that the criminal conduct has been proved, then it is presumed that no employer would like to keep the criminal in the employment. That is the reason that there is no reason to again have the inquiry. The second is very, very important, which is invoked by the employer many a times, and that is 311(2)(b). It says, wherein the authority empowered to dismiss, remove, or reduce a person in rank is satisfied for reasons to be recorded in writing by that authority, that it is reasonably not practicable to hold the inquiry. Now, it's a very wide term without any parameters being laid down when it is reasonably practicable to hold the inquiry and when it is not. If time permits, I'll elaborate on this point also. Then the inquiry can be dispensed with. And the third one is when the president or the governor is satisfied that in the interest of the security of the state, it will not be expedient to hold the inquiry. Except in these situations, the penalties of dismissal, removal, and reduction rank, I'll come to the penalties in detail in a short while, but I'm just making a reference here. They cannot be taken unless there is an inquiry. The third very general statement which I would like to make is that mostly in every department, there are conduct rules and there are punishment and appeal rules. The procedure prescribed in those punishment and appeal rules has to be followed. For example, we make reference to the central government rules, then CCA rules of 1965 are the relevant rules of 1965, and we have the conduct rules of 1964. The violation of conduct rules leads to the imposition of penalties, which are of 2 types, which I'll come in a while: minor penalties and the major penalties. In imposing penalties, the procedure to be followed is of utmost importance. And many a times, the inquiry might have been conducted properly, but the procedure has been violated. And that includes even the following of the principles of natural justice. The inquiry can be set aside and the desired result may not be achieved. I may remind here that strictly speaking, the Civil Procedure Code and the Evidence Act does not apply to the inquiry, but the principles contained in therein, they are applicable. And one of the most important point which one must remember, that departmental inquiries are totally different from other kinds of inquiries which are conducted under the Inquiries Act or CBI inquiry or the police inquiry. There, the procedure is totally different. We are talking about today only those inquiries and the penalties under the conduct rules or the punishment and appeal rules in the service law. And another important point we can discuss here is that many a times what happens is person is also facing a criminal trial and he's in employment too. Can we hold the departmental inquiry when the criminal trial is going on? At the very outset, let me point out, yes, the departmental inquiry may be held even when the criminal trial is going on. The only hurdle is the delinquent, who is the charged official, what we call in the service law language, if he says, I will not disclose my evidence to you because that will prejudice my case in the criminal court, then you can't force him to disclose the evidence because the criminal trial is of utmost importance for him and he can't be forced to declare his evidence beforehand in the departmental inquiry. Otherwise, legally speaking, yes, the departmental inquiry as well as the criminal trial, they can go simultaneously. Now, let us come to the topic that major, the minor and the major penalties. In CCA rules of 1965, which can be referred to generally because in the state also the state punishment and appeal rules are exactly on the similar line, only the rule number may be different. Here you will find Rule 11 talks about penalties. Now the most important part with regard to the imposition of penalty which one has to note is, if you go through the language of Rule 11 of CCA rules of 1965, then it says the following penalties may, please note, for good and sufficient reasons and as hereinafter provided, be imposed on the government servant. So the condition precedent before we talk about the penalty is there must be existence of good and sufficient reason to initiate a procedure against any government employee. No employer should start the procedure for imposition of the penalty, be it a minor or be it a major, unless there is good and sufficient reason, so that there is no harassment as far as the government employee is concerned. Let me also make it very clear here that starting the departmental inquiries against an employee is not imposition of minor or major penalty. It is a part of the procedure and you can follow the procedure. That is not imposition of any kind of penalty. Now, under the punishment and appeal rules, there are two types of penalties. One are called minor penalty, other are called major penalty. Now, if you go by the CCA rule, in the category of minor penalty, warning is not mentioned as a penalty. Warning is when you just warn a person, it may be oral, it may be in writing, but when you do not keep that warning in the personal dossier of the CR dossier of the employee, it is not considered a penalty. But if you make it a formal punishment as a formal warning, then that takes the shape of censure. So censure is the first minor penalty which is mentioned in Rule 11 of the CCA rules of 1965. The second kind of minor penalty is withholding of his promotion. Withholding of promotion is also a kind of a minor penalty because subsequently it can be restored. But again, there must be good and sufficient reason to impose the penalty, and the procedure to impose the penalty that must be followed. The third minor penalty which is considered is recovery from the pay, the whole or part of any pecuniary loss caused by him to the government by negligence or by breach of contract or breach of the orders. Now, that is also considered as a minor punishment. Uh, Another kind of a minor punishment or a minor penalty is reduction to a lower stage in a time scale of pay for a period not exceeding 3 years without any cumulative effect and not adversely affecting the pension of the concerned employee, and the withholding of the increment of pay. These are considered as the minor penalties. The other category of penalties which are stipulated under Rule 11 of CCA rules or under other relevant rules of the concerned departments are dismissal from the service. Secondly, removal from the service. I will come to explain you the difference between dismissal and removal. The third is compulsory retirement without following the relevant rules of the compulsory retirement and conditions of compulsory retirement. The fourth one is reduction in rank. Now, reduction in rank can be to the lower stage or it may be in the same cadre but to the lower stage. But while we are talking about the reduction in rank, one point has to be mentioned. Many a times the employee joins a particular cadre directly at a particular stage. Say, for example, in the police department, a person has joined directly as a deputy superintendent of police, and he is facing the departmental inquiry, the charges are approved, and a reduction in rank is decided. He can't be reduced in a rank below the rank of deputy superintendent of police. That means the entry point in a particular employment where the person entered into the service, below that he can't be reduced. If he has gone up the ladder by having a promotion, then that lowering of the rank to the lower stage can be there. There are certain situations when the action of the department is not considered as a penalty. For example, withholding of the increment of the government servant for his failure to pass the departmental examination. In many of the departments, there are conditions that for promotions, he must pass the departmental examination. And if he fails to do so, it is not considered as the punishment. Similarly, stoppage of the government servant at the efficiency bar. That is, if in certain department there is an efficiency bar which has to be crossed by the employee during the service. So if he fails to cross that efficiency bar as per the departmental rules, it is not considered any kind of a punishment. Non-promotion of the servant, whether in substantive or officiating capacity, after considering his case to the service, grade, or the post for promotion to which he is eligible. Meaning thereby that many a times persons are considered for promotion, but they are not promoted because of the various internal factors. Taking into consideration those factors, the competent authority decides that he is not
So you will have to log in. So unmute yourself. Yes.
Yes. Sorry, there was a technical glitch. I'll continue with it. Reversion of a government servant who is officiating on the higher service grade or post to a lower grade or post when he is officiating, that is also not considered to be any kind of a penalty. Similarly, a reversion of a government servant who is appointed on a probation to any other service grade or post to his permanent service, then that is also not considered as the punishment. Except such kind of conditions. So broadly speaking, we have minor punishment and the major punishment, the two kinds of punishment which can be imposed. So these are the kind or category of penalties. The most important question is, what is the procedure to impose these punishment? Now, normally what happened, we have to take into consideration the operative part of Rule 11, that the punishment can be imposed for good and sufficient reason and not in a normal routine manner. So the occasion to impose minor punishment or a major punishment arises when the employer himself observes certain things in the employee which deserve the penalty to be imposed, or any kind of a complaint is made. Now, before I elaborate the procedure, let me also talk about a little bit about the conduct rules. In every employment, there are certain conduct rules. And in government department, or if I say the central government conduct rules of 1964, particularly Rule 3 talks about three things. One, every employee of the government should do his duty with utmost integrity, show full devotion to the duty, and thirdly, should not do any act which is unbecoming of an employee of that organization. There are certain acts which are defined, or I would say rather explained by way of illustration, which any employee should not do. Otherwise, that act amounts to doing an act of becoming an unbecoming of an employee of the organization. For example, an employee of the government start demanding dowry. Now, that is not a conduct which is accepted of a government employee. Similarly, a government employee start accepting bribes. It is a conduct which is against the integrity and honesty of the employee. So it becomes a misconduct. Misconduct is also explained there. But if any conduct of an employee, because the human mind is very fertile, we can carve out directly or indirectly any kind of an action which may not be directly covered within the strict parameters of any definition of the misconduct as explained in the conduct rules. However, if any act that amounts to unbecoming an employee of that organization, then Rule 3 of the conduct rule is attracted, and in that case, the person may face proceedings, the disciplinary proceeding, what we call against the employee for imposition of any employee. Now, what happens is, the first stage is when you receive a complaint. The complaint may be an anonymous complaint, or it may be authenticated complaint with a proper affidavit of the complainant. The general rule of the vigilance department are that no action is required to be taken when there is anonymous complaint, because many a times the disgruntled people, dissatisfied people with the honest employees, they keep filing anonymous complaints also. However, if the employee feels that the allegations leveled even in the anonymous complaint are of serious nature, they include serious allegations which destroys the reputation or the working of the very employment of which the person concerned is an employee, there is nothing which stops the employer to further probe into that complaint which is anonymous. Or the other complaint I told you is the authenticated complaint, on which, of course, the employer can initiate action. And to proceed further, the first stage is of conducting a preliminary inquiry. I must lay emphasis here to all the listeners. Preliminary inquiry is totally different from regular inquiry in the procedure. Preliminary inquiry under the law is not even mandatory to conduct. But in practice, as a proper procedure, the preliminary inquiry should be conducted. Preliminary inquiry is also known as the fact-finding inquiry. Now, why it should be conducted? The reason is, many a times when the complaint is received by the employer or a conduct is observed by the employer which is of unbecoming an employee of the organization, you have to issue him the charge sheet or level allegation, and you need evidence to prove. If you have the charges but you don't have the evidence, you can't prove the charges. And without proving the charges, you cannot take action. So, initiating an inquiry against the employee where you do not have the sufficient evidence to support or prove the charges will be totally futile, and the employee will become more our employee may start violating more and more the rules of the department, because he thinks that nothing can be done against me, no action can be taken against me. So the first step is to conduct the preliminary inquiry. In the preliminary inquiry, try to find out more and more evidence to prove the charges. Preliminary inquiry can be conducted by informing the delinquent or without informing the delinquent. It may be within the department or outside. Whatever method you consider proper, accordingly the preliminary inquiry can be conducted. And once you have the sufficient evidence, then you have to proceed further. And one of the stages, which is again not mandatory, and it is very important to understand, that in certain situations, depending upon the duty which a particular employee is discharging at that particular point of time, and the records under his charge, it may be advisable to suspend the person from the post. Let me make it again very clear. In legal terms, as such, suspension is not considered a kind of penalty. When I refer to Rule 11 of the CCA rules, I did not mention suspension. The literal meaning of the suspension is to keep the person away from the place of work. Why should we keep the person away from the place of work? There are two reasons for that. Reason number one is there may be a very important and a relevant record under his direct control. And if he is not kept away from the seat or the place of his work, he may destroy that evidence, that material evidence, and it may be difficult to prove the charges against him. Say, for example, a person is sitting on a public window to receive the cash receipt from the public, and he has printed his bogus receipts also, or receipt books also. After every 5 or 6 genuine receipts, he is giving one bogus receipt. Now that bogus receipt book is under his control. And if you are trying to probe this charge, he may destroy all the bogus receipts books from his seat. So this is one. Secondly, if he's allowed to come to office, he may try to influence the material evidence or the witnesses who may be there in his office, or try to change their mindset. So therefore, suspension may be resorted to. Now, with regard to suspension, again, we have to understand, though it is not a kind of a minor or a major penalty, but it does operate to a normal human being as a concealed form of penalty. A person who is honest, person who is doing his duty with devotion, the person who does not believe in doing the wrong thing or doing any act which is unbecoming of the act of the organization or employee of the organization, if he is suspended as a routine matter, that person may feel bad. And there are examples, some persons have even gone into depression because of the suspension order which was imposed on routine matter. So though at the cost of repetition, I must repeat, suspension is not a punishment. It is only a concealed form of a punishment, not in the legal terms as such. And secondly, it should not be resorted to as a routine matter. There are few questions which arise of our consideration. That is, who is the person who is competent to suspend the person, and when a person can be placed under suspension. The authorities who can suspend the employee, they are appointing authority. Number two, any authority to which such authority is subordinate, that is the appointing authority, superior authority to that, the disciplinary authority, or any authority which is empowered by the government, by the president, or by a special order in this behalf. They are the authority which are competent to suspend the person. Now, when a person can be placed under suspension, when disciplinary proceedings are pending or even contemplated. Even when they are contemplated or when they are pending, the person can be placed under suspension. That is what is provided under Rule 10 of the CCA rule. Or where, in the opinion of the authority, he has engaged himself in activities which are prejudiced to the interest of the security of the state. And thirdly, where a case against him in respect of any criminal offense is under investigation, under inquiry, or under trial. In all these circumstances, the person can be suspended. There is another concept, what is called a deemed suspension. I will not go into the detail, but I just mentioned, if a person is detained for more than 48 hours, then from the time of his detention, he is deemed to be under suspension. Similarly, if a person is punished for committing a criminal offense and imprisoned for a period of more than 48 hours, then again he is deemed to be under suspension. And when a person is served with the order of suspension or deemed to have been suspended, as I explained above, such suspension shall continue and remain force until it is modified or revoked by the competent authority who is competent to revoke or modify. Meaning thereby that once a suspension order or a deemed suspension is there, then under Rule 10, Clause 5, it is mandatory to pass another order revoking or modifying the suspension order. So, coming back to the procedure, depending upon the gravity of an offense which a person has committed, the competent authority will decide whether the person is to be suspended or not. Then the next is, after we have decided whether the person should be suspended or not, we have to follow a procedure for imposition of minor or a major penalty. Now, the procedure for imposition of both minor penalty as well as major penalty, they are different. One basic principle we must keep in mind, that penalty to be imposed is directly proportional to the gravity of the offense the person has committed, the misconduct the person has committed under the relevant conduct rules of the concerned department. For a minor offense, say for example, a person has been coming late to the office. He is violating the conduct rules. But can he be dismissed from the service? No, because dismissal is the extremest possible kind of a departmental penalty which can be imposed. So, first of all, the disciplinary authority has to decide what is the kind of misconduct the person has committed. If it is of a minor nature, then any of the minor penalty, which Rule 11, I have already illustrated that can be imposed. For imposition of minor penalty, the procedure is prescribed under Rule 16 of the CCA rules, which is very simple. The rule says simply, issue him a show cause notice, alleging the allegation, whatever allegations you have against the person, asking him to explain his conduct within the certain period of 10 days, failing which it shall be presumed that he has nothing to say in his defense. And that show cause notice is served to the person concerned. Now, within that stipulated period, in which you have informed the delinquent, here the person against whom the action is to be taken is called delinquent. Now, that delinquent has a time and opportunity to reply back that he has not committed or it is wrongly inferred that he has committed. I give you a simple example. Mr. X has gone on a duty leave to attend a refresher course in the university. With the same name, there is another Mr. X in the same department, and somebody complains that Mr. X is absent without any authority. And the department issues a show cause to other man who has gone with the permission of the department. He would come and say, I have not gone without permission. I have gone with the permission. Here is the authority. I have been attending the duty as in the refresher course or whatever duty the employer has asked for. So there is a miscommunication. So once the reply of the delinquent comes, that reply has to be considered with the open and objective mind by the disciplinary authority. And if finds the reply is satisfactory, please note, this is very important. Many a times the people think that once procedure to initiate disciplinary action has been initiated, some kind of punishment has to be imposed. In my considered view, this is totally a wrong approach. You have given him a show cause notice. He has replied to the show cause notice. The reply is found to be satisfactory. Then the operative part of Rule 11 comes into play, which says penalty can be imposed only for good and sufficient reason. I'm of the considered view that if once reply is found to be satisfactory, the person is not to be served with any penalty because there is no good and sufficient reason in existence. And the matter should be closed at that stage by recording the reasons. Now, if the reply is found to be not satisfactory, again, depending upon the person who has committed a misconduct of a minor nature, he can be imposed with the minor penalty after recording the reason, opinion why the reply was not found satisfactory. Many a time the question arises in the day-to-day employment, which is very important. I will call, but that is called the dies non. A person comes to the office late and habitually come late. Or person comes to the office, you give him or her the work and he or she does not perform the work. Now, or person came to the office on time, but he leaves the office without permission. He comes back after some time. Now, what do you do? To such situations, there is a term which is used, dies non, D-I-E-S, dies N-O-N, dies non. That means neither that day is considered as a service, nor it is considered as break in service. But if a person is coming late, say little late to the office, and the whole day he's performing full duty, rather sitting late also and finishing his work, then in that case, the dies non does not apply. At the most, if a person becomes a habitual, you can deduct his casual leave or other kind of a due leave, but the dies non will not be applicable. The other category of punishment, that is the major punishment, that is very, very important. Since the time left at my disposal is very short, only 10 minutes or so, I'll try to finish it as early as possible. The detailed procedure for imposition of a major penalty is prescribed under Rule 14 of the CCA rules. And in Rule 14, the procedure is, at the very outset, once the disciplinary authority is of the considered view that the person has committed an act which deserves a major punishment, then the authority have to frame the charge sheet. Now, framing of a charge sheet is also an art. It is not as simple, but no prescribed performa is there in the rule. In a layman language, a charge sheet consists of 4 components. There are 4 components of, or if I have to, in a layman language, define what is the charge sheet, I would say a sheet containing charges is called charge sheet. But in the law, that definition may not exist. In law, a charge sheet a valid charge sheet must have 4 things in it. Number 1, statement of charges. Statement of charges means specific acquisitions. Specific acquisition means, say, for example, a person has claimed false TA from the employer. So the charge becomes claiming of false TA. Charge number 1, hence violation of rule number so and so. If no rule is directly violated of the rule of the conduct rules, then definitely rule number 3 is attracted, that is doing an act which is unbecoming an employee of that organization. Component number 2 of the charge sheet, statement of allegations. The charge which you have mentioned, that must be explained in detail so that while going through that charge or that statement of allegation, person can remember. Employee may be going from Chandigarh to Delhi almost once in a week. He may not remember when he claimed wrong TA. So you have to mention that on such and such date, you were directed to go to such and such place. You went in official vehicle of the department, whereas you claimed TA also from the governments, and therefore that is false claim of TA. Why your TA claim number so and so, of which the payment has been made to you, wide check number so and so. The entire detail about that charge has to be given in the statement of allegation, so that by reading those allegations, the person can come to know about the incident regarding which the charge is there. The component number 3 is the list of witnesses. Who are the relevant witnesses who know about the particular charge? If you have no witness, you can mention there are no witnesses. But if the witnesses, the department intends to prove before the inquiry, the list of witnesses is to be mentioned. And component 4 is list of documents. Like, for example, I mentioned about claiming a false TA and traveling in the official vehicle. So the relevant witness would be the driver of the vehicle who drove the vehicle. The relevant document would be the logbook of the vehicle, the toll tax receipts of the vehicle, the time of arrival and doing the work in a particular department or office, that may be again relevant for this purpose. So all of these four things should be mentioned. Now, once the charge sheet is submitted, is prepared, it should be prepared with the open mind without disclosing the guilt. You are only alleging the guilt. The competent authority or the disciplinary authority should not vomit out in any direct or indirect language in the charge sheet that the delinquent is guilty. You are only alleging those things which the delinquent is competent to rebut by his own defense. So he is given the time to rebut back, to file his reply. The reply is required to be again considered by the disciplinary authority. And I am of the considered view that it is open for the delinquent to accept the charges, to deny the charges in totality, or give the reason, detailed reasons that charges are unfounded. If the charges are accepted, the disciplinary authority can see the record and accordingly take a decision which punishment is to be imposed, because the charges have already been accepted. There is no need to further go into the procedure. If the charges are denied, the further inquiry is to be conducted. If the detailed reply is submitted, the reply is to be considered. And as I said, I am of the considered view, if reply is found to be satisfactory at this stage, the inquiry should be stopped. It is not necessary to continue with the inquiry merely because the charge sheet has been issued. There are different views on this point, but I take always this pragmatic view. If reply is found to be not satisfactory, then further two important appointments are to be made by the department. Number one, the appointment of the presenting officer. Presenting officer is like a public prosecutor in the government department. The presenting officer has to present the case of the department on the basis of the documentary evidence available in the possession of the department and the witnesses there, if any. Now, the presenting officer should be a sufficiently experienced person because he has to plead the case before the inquiry authority. The second appointment is of inquiry officer. Sometimes it may be inquiry committee consisting of more than one person also. The inquiry officer as well as the inquiry committee may be from within the department or outside the department. Similarly, the presenting officer, generally speaking, he is the person from within the department, but you can have from outside as well. At the same time, you have to give an opportunity to the delinquent that he is to choose his defense assistants to defend him. Or here, many a time the question arises, can the delinquent engage a lawyer? The answer to this question depends who is the presenting officer. I'm not talking about who is the inquiry officer. Inquiry officer should be sufficiently senior to the delinquent officer and not junior to the delinquent officer. One more precaution has to be taken into consideration, that the person who has conducted the preliminary inquiry should not conduct the regular inquiry, because he has already given his finding whether the person is having evidence of committing an act or committing a misconduct which is unbecoming of an employee of the organization, and he would like to stand by that. And therefore, the person who conducted the preliminary inquiry cannot be the regular inquiry officer. Now, with regard to the lawyer, the question of a lawyer, I told in the very beginning that departmental inquiries are different from other inquiries under the Inquiries Act or the CBI inquiry or the police inquiry. Here, unless the presenting officer is a practicing lawyer, the delinquent does not have got the right to engage a lawyer. The mere fact that presenting officer is having a degree of LLB or he is law qualified does not provide any right to the delinquent that he can engage a lawyer. He can ask for any person from within the department to defend him. And if the presenting officer is a practicing lawyer, then the delinquent has full right under the Constitution, or to balance the scale of justice, that he should also be provided with the help of lawyer. But if otherwise the department wants to permit a lawyer, despite the fact the presenting officer is not a practicing advocate, there is nothing wrong in that, but the delinquent cannot ask for the lawyer as a matter of right in this situation. So after you have done these appointments, the original record goes to the presenting officer, a copy of the record goes to the inquiry officer, and the inquiry officer, after having received and accepted that that he will conduct the inquiry, he will fix the first date, which is called preliminary hearing. Please mark my word, preliminary hearing is different from preliminary inquiry. Preliminary inquiry was a fact-finding inquiry. Here in preliminary hearing, he will inform the delinquent that he has been appointed as an inquiry officer and you are directed to come to a particular place, time, date, everything in detail. And there he will ask, has he got the copy of the charge sheet or not? If he has not received, he can again ask for a copy of the charge sheet, and he can give the charge sheet again. And it is at this stage, he can also ask the delinquent, will he like to see the documents which the department is to produce in the inquiry. If he wants to inspect those documents or he wants to have a copy of them. Today, in these days, the Xerox copying or scanning has become so easy. It is available in your handset of mobile. It should be permitted, but in the presence of the departmental official. Otherwise, delinquent may sometimes destroy the most relevant record. Here, the documents are of two types. The first category of document, what we call unclassified document, or those documents on which the department wants to rely upon to prove the charges. To such document, the delinquent has a right to see and even take a copy of the document to prepare his valid defense. But there are certain classified documents, or to which the department is not even trying to rely upon. Normally, what happens is department is relying upon two small documents, whereas the delinquent asks about 4,000 documents, which is irrelevant. So the inquiry officer has to pass an order that whether he permits the certain documents or he does not permit, depending upon the fact that the document asked by the delinquent is relevant in the inquiry or not. Another factor which is very important here is that I told you in the very beginning in general statement that the principles of natural justice are applicable. The principle of natural justice, in nutshell, there are three principles of natural justice. One is called absence of bias. Bias means the favor or disfavor towards a person. Second is the audi altum partem, that is the hearing. And third is the reasoned decision. Now, bias is maybe that the inquiry officer is such a person who does not like the delinquent, or the delinquent also does not like the inquiry officer, and he thinks that he may give a biased opinion. So he can raise the plea of a bias at the very outset. Please remember it. There are category of cases that if at all the delinquent believes that there is a bias, the inquiry officer is biased, the plea of bias is to be raised at the earliest available opportunity. And if you do not raise this at the earliest available opportunity, you deem to have waived your right, and subsequently, though there is a bias, but this plea will not be helpful to you to quash the proceeding. So once this is done, then document verification is there. Then the regular inquiry starts. First of all, the presenting officer says charge number 1, reads the allegation, proves the allegation with document, evidence, which can be cross-examined by the defense assistant or by the charged official. by one, he will prove the charges. It is not essential that you should have multiple charges. Single charge is sufficient to dismiss a person. 10 charges may not be sufficient to take any action. It depends on the gravity and probability of the proving of the charges. That is very much material. Once the charges have been proved by the presenting officer before the inquiry officer, then the turn of the charged official comes. He will produce his documents, he'll produce his witnesses, he'll try to demolish each charge one by one. And if any witness is produced by the charged official or defense assistant, that can be cross-examined by the presenting officer. Please, 2 points should be taken note of at this stage. Inquiry officer is acting like a judge. Therefore, inquiry officer is not competent to cross-examine any witness. It is the prerogative of the defense assistant or charged official or the presenting officer, as the case may be. Presenting officer has to record daily order sheet, which has to be given to both presenting officer as well as the charged official after obtaining their signature, so as to put the record straight and transparent. After both the sides have argued, put up their case, there are oral arguments, and then it comes the writing of the report. The writing of report is again art. The obligation of the inquiry officer is that he has to refer to all the charges one by one, the evidence in brief, and finding on each charges. The inquiry officer can say charge is proved or charge is not proved, but he should not write charge is disproved. Or inquiry officer is having no authority. Please mark my word. Inquiry officer has no authority to recommend any punishment. It is the job of the disciplinary authority to decide what punishment is to be imposed, major or minor, depending upon the gravity of offense. I did not tell you the difference between dismissal and removal. In both the cases, the termination of service is there. The difference basically is, in case of a dismissed employee, he cannot join that government service or any other government service in any state. Whereas under the removal, termination of service is there, but that does not bar him to join back the same service or some other service in a different state or under the different government. That is the basic difference. After the inquiry report has been submitted to the disciplinary authority, it is mandatory requirement. There is a law particularly laid down by the Supreme Court in 1993 Constitution Bench. This is the Managing Director, Electronic Corporation of India Limited versus B. Karunakaran. All service lawyers, they rely upon this important judgment. There have been subsequent judgments also, but this was the case, second case where it was laid down. Irrespective of the language of your service rules, supply of inquiry report is mandatory. And if it is not supplied to the delinquent before imposition of the penalty, he can challenge that in the court of law, and he will have to prove before the court that what civil consequences were visited on him because of non-supply of the inquiry report, and accordingly the court can direct to supply him the inquiry report, and subsequently he can supply his report. Now thereafter, after he has given his reply again against the inquiry report or on the inquiry report, the disciplinary authority has to provide second opportunity of hearing, despite the fact the same has been deleted from Article 311 of the Constitution in 1976. But by virtue of the case law, the second opportunity that why this punishment should not be imposed, that has to be conveyed to the delinquent. And thereafter, if the delinquent is not satisfied with the action of a disciplinary authority under the relevant rules, he has a right to review, revision, and appeal, and finally go to the court of law, and he can have the justice from the court of law. This is, in short, is the procedure. I have jumped a number of steps in between, but broadly covered whatever are the major steps for conducting the inquiry and the legal perspective. Thank you very much, Vikas, for providing me this opportunity to share my views on minor, major penalties, procedure for imposition, and the legal perspective. Thank you all the viewers who could spare their time to listen to this lecture.
So I can only say that, as they say, some things only get better with time, and that was with you today. What we heard you in 1994, 93 onwards to 1994, qua service matter, it has only got better. And the way you carried the things forward, it brought me back to the memories of the university days when we were. So I think you have logged out. I'm just checking it out. Unmute. Yes, sir. You will have to unmute yourself.
Yes, I have done.
Yes, sir. So I am saying that I am reminded of MS Gill's judgment, though it was used in a different context, that you cannot, the speaking orders cannot be like old wines which can get better with time. But I definitely can say that you got better with time. In 26 years after hearing you on the platform, it was a pleasure. And one of your again student, she's also practicing, she's a deputy advocate general. Monica Jalota also says that she's reminiscent of the 1995 batch. So you have rekindled those memories and the spirit. Learning from an academician and from a jurist is always a pleasure. And now, since we will be taking the questions, and I've seen a lot of people from your SRM have also logged in.
Yes.
This is by Stephens. After a decision of a disciplinary authority and appeal made by the appellate authority, the appellate authority has not given a decision into the same for past 8 years in spite of reminders. How to deal with the same?
Go to the High Court. Whenever go to under 226, go to the High Court and challenge it that there is no decision coming up, because as such under Rule 14 also no time limit is given or on the appeal provision, but it should be within the reasonable time.
So that is one of the judgments says that if you don't do it within in a time bound manner, because in writs they say it's a period of 3 years. The Supreme Court in one of the judgments says that if you do not come, you could also be thrown out on the delay and latches. So better recourse is to come on time. Sir, if the management employer produced any forged document during inquiry, can we file a criminal case against him?
Why not? Why not? Forgery, it's a criminal offense itself.
This is by Leti. Leti praises you. One of the best sessions I've ever heard, with seniority and the great, crisp, clear message session of respected sir.
Thank you so much. Thank you.
Abhishek says, how will the delinquent lawyer find out the qualification of the presenting officer in an explained case?
I didn't get a question.
He says, how will you come to know that what is the qualification of the delinquent?
You can ask if you do not have the idea, or mainly the presenting officer is from within the department. But you can ask in writing whether he is a practicing advocate or not.
Yeah. Normally, otherwise people do come to know that what is the.
Normally, it is within the department. Everybody is known nowadays. Why to talk about within the department? You know about other country also. What is the qualification of a person?
Yes, sir, you just Google it out. This is, sir, please explain, take up this question. Violation of number.
Which
violation
one?
of number this and this established. Stephen, you will have to pose the question properly. I'm just seeing it on the YouTube whether we have any questions. There was some. So
I don't know.
Meanwhile, Mr. K.L. Singla asks, if in an autonomous
before you ask a question, let me respond to that number. let me make an open confession. I am not a practicing lawyer. I am not now even teaching service law. Since last about 12 years, I have not even taught service law. So I am not knowing what are the notification numbers are being issued.
So
I have
notification
taught.
number, even the lawyers would rarely come to know.
Even lawyer will have to go through the document to find out the lacuna in that. And particularly what I spoke today is the general principles of law. Not there may be a specific case, a specific fact. In law, the facts, they turn the case totally.
Even the rules, sir. I'll
Even
just
the
give an
rules.
example. Rule 2.2
Even the
of
rules, yes, I fully agree. I fully agree.
I have just given a classic example. Rule 2.2 of Punjab Civil Services rules and Rule 2.2 of Haryana Civil Services rules. Just as a one different word, and it is a different. Rule 3.17 in respect of counting of the previous service in state of Haryana and state of Punjab is slightly different. It's state of Haryana says any service followed by regularization is countable towards the pensionary benefits.
Yeah, so that is why in the beginning I said the general statement that service law is regulated by constitution, rules of the department and case law. I said the very first sentence. I said that.
This is Rahul says, if the charged officer knows Hindi and the charge sheet supplied is in English and all decision of the appellate authority and communication made is in English, can we challenge?
He has a right. That is a very simple. There is a curtain of judgment. The communication has to be in a language which the charged official understands.
Yes.
You will have to. You may record in English, but you have to supply the translated copy, certified translated copy to the charged official.
Or you will have to write that it has been made him understood.
Yes.
This is by K.L. Singla. If in a government autonomous body which falls out, which follows government rules, the discipline authority in its governing body, and there is no appellate authority prescribed in the rules, does any statutory appeal lie against the governing body?
No, when there is no in the autonomous body there is no appellate authority provided, then naturally the consequences that you have to go to the High Court.
Yes.
You will not create authority for a particular purpose.
And whether a government employee dismissed from government service be given an employment in some government autonomous bodies and public service, PSUs or
any government for total funded department, it is prohibited. Dismissed employee, removed person can be given,
and that too if it is written not to affect the future service.
Yes.
Yes.
I am glad that Vikas is supplementing my answer very well.
No, I'm just learning from you. If an SHO
no, that is the correct position. I'm completing the sentence.
What is Iftikhar says if an SHO overdoes what he is supposed to do, can he be punished and what is the procedure?
No, what he overdoes, that is again, it is a factual. I mean, there is no blanket answer to a question. What he overdoes, that has to be evaluated. Whether that amounts to doing an act which is unbecoming of an employee of the police department or not. Yes. That has to be seen. Again, for imposition of penalty, please remember that operative 2 words, for good and sufficient reason. If you do not have good reason, if you do not have the sufficient reasons, you cannot impose the penalty. That would be a futile exercise. Rather, that encourages the employees to do violation because they know nothing is going to happen.
And be that as it may, there are 2 further facets. I will just buttress that. It says that if it is a grave misconduct, yes, you can be punished. If it is a negligence, yes. Then 1979 Supreme Court says that if it is not based upon malafide, but it is a negligence, what you expect someone to do, but he does not do. That is a negligence, but not as misconduct. Because for a misconduct, the edifice has to be a malice in his conduct.
In other words, there is a very important saying which I follow in my administration also. Error of intention will not be spared, but error of judgment can be spared.
That's true. And it is just like when we were talking about you, sir, you should come on the platform. One procedure was, I could have said that sir is not coming, we will not ask him to come on the platform. But I reminded myself, it is better to try and fail rather than failing to try. And we ultimately succeeded to bring you on the platform.
No, I had told you that in 2021 I will come straight away.
Yeah.
I had told you.
For that, we can always say, at the first brush, I said that we can always thump our chest that we are a proud student of yours. So, friends, it was a fascinating session. One process was always in the mind that from whom we have learned, the other speakers should also come to know, the other participants should also come to know that what knowledge sir can share. And it is always a pleasure hearing him on the platform, outside the platform, as a student of law, as a person. It's always a pleasure connecting with him. So everyone stay safe, stay blessed. And before we part for today, join us tomorrow again on another fascinating aspects of law, Indian Succession Act 1925, will, execution and proof, by Justice Rajiv Bhalla, a former judge of Punjab Haryana High Court. And friends, I would like to share, we would be having 3 sessions with Justice Bhalla on 3 different Sundays. The second session would be on 24th, Indian Succession Act 1925, probate and letters of administration. And third would be Indian Succession Act, the succession certificate. So thank you, stay safe, stay blessed, and sir, keep blessing.